Uamuzi kuhusu fidia kwa waathiriwa wa mkasa wa bomu uliotokea tarehe 7 mwezi Agosti mwaka 1998 unatolewa na mahakama hii leo baada ya hatua hiyo kuahirishwa mwishoni mwa mwaka jana na Jaji Lawrence Mugambi akiomba muda zaidi kuangalia kwa umakini zaidi faili za ripoti za kesi hiyo.
Considering the gravity of the impact, the petitioners prioritized their health prior to seeking justice. This caused a massive financial strain that impacted on their ability to file this suit promptly. That this fact is what informed the petitioner's decision to approach the first petitioner for legal assistance. Moreover, they argued that in the case of Eliud Wefafwa Ruucho and 3 others versus Attorney General, and in the case of Nairobi Legal Advice Center Kituo Sheria versus AG and others, and Wamwere and 5 others versus AG, it was held that limitation of time does not apply in respect of matters alleging breach of fundamental rights. Judicial precedents have now firmly established that in cases involving violation in respect of human rights, they are not affected by limitation of time so long as a delay in instituting the case has been satisfactorily explained to the court. That was the finding of the court in Dambuki versus Dungu and others, which is a High Court decision. It's a long quotation, I will not go through it. Then there was also another case of Pitangari, Karume and others versus AG, which was also on the same point. In the instant case, the petitioners have given reasons why they delayed in taking legal action. One is that they had been in constant engagement with the respondents over the years, with the respondent giving them hope that their matter was under consideration. The respondents did not deny that they had engaged in some discussions with the petitioners on the issue for years with a view to finding a solution. Further, the petitioners cited the fact that they had been experiencing financial challenges as there are demands on them in terms of health expenses. As a result, they had to approach the first petitioner for legal assistance to pursue this matter on their behalf. Despite the respondents claiming that they have suffered prejudice as a result of delay in filing this petition by the petitioners, they did not contest the fact that they have been engaging in a conversation around the issue with the petitioners for several years. They cannot thus face surprise of the issues at hand. Further, they did not articulate the exact nature of prejudice that they have suffered in defending the petition, other than making the general statement. I find the explanation given by the petitioners for the delay in filing the petition as satisfactory, hence the delay in filing the petition is thus valid and excusable. I'll now go to the issue number 2, which is whether, in the light of the evidence relied upon by the petitioners, which are reports, publications, and judgment by courts in the United States, and the totality of the circumstances of this case, the petitioners have established, on a balance of probabilities, that the government of Kenya failed to discharge its positive obligation to protect Kenyans against the Al-Qaeda attack that targeted the United States Embassy in Nairobi in 1998. This is the foundational issue upon the petition rests. The resolution of this issue will determine whether the court can consider the other issues in this petition, as it settles the question of liability in respect of the actions complained of. The question thus becomes, does the evidence presented demonstrate the respondent's failure to take reasonable steps to prevent the occurrence of the U.S. Embassy terrorist attack in 1998? The petitioner's case is that the 1988 U.S. bomb attack by Al-Qaeda terrorists happened because the government of Kenya's neglect to act on repeated early warnings to prevent and stop the terrorist attack.
Na mtazamaji